thank you for taking the time to get together for some conversation about the original understanding of the First Amendment, religious freedom provisions, which are a vexed topic these days in U.S. Supreme Court jurisprudence. Originalism as a project and a form of constitutional interpretation has been deeply contested. It is an area of a great variety of different voices, and I'm not interested in that part of it. I come to you as a legal historian. I'm interested less in what the First Amendment religious freedom guarantees became in the hands of the U.S. Supreme Court, and more interested in where they came from. And to get a sense from the founding era of circa 1760 to 1800, what is clear and what is less clear about the final 16 words that comprise the First Amendment religious freedom guarantee. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That language, as you saw in the article, was crafted by the first Congress in the summer of 1789. It was ratified by the requisite ninth state in December 1791, and it has been the law of the land of the United States to this day. It's been subject to 266 or so U.S. Supreme Court cases and many thousands of lower federal court cases interpreting and applying the constitutional prohibitions on establishments of religion and guarantees of free exercise of religion. The documents that we have to come to an understanding of those original words really are a variety of different sources, formal and informal. And what I want to zero in on relatively quickly are the 25 drafts of the religion clauses that ultimately were part of the official record and part of the conversation that informed the House and the Senate debates on the ultimate state ratification debates of those final 16 words. And I have in that appendix to the article that was circulated those 25 drafts sitting there, to which I'll be making occasional reference and then zeroing in on as we try to parse the final words that we have before us. Just a quick elementary reminder of where we are in American constitutional and political history. Before 1776, America is a collection of 13 individual colonies, each of them under a colonial charter held by the British Crown. That charter stipulated the rights and powers that were available to the colonists, and the story of the 1760s and 1770s is a gradual set of restraints and restrictions, and ultimately, in the eyes of the colonist, abuses that attached to the exercise of power by the British Crown, and ultimately a revocation of a declaration proclaiming the absence of those colonial charters as a ground for constitutional objection. And in response to that comes the American Revolution. And the American Revolution, even as it is going on, gives rise through the Declaration of Independence to a collection now of 13 United States. And those 13 United States are jealous about their individual sovereignty and prerogatives. And as the Revolutionary War is still going on, the 13 states begin actively crafting their own state constitutions. Between 1776 and 84, 11 of the 13 states have new state constitutions in place with elaborated powers and elaborated rights provisions, including on religious freedom. Two of the states, Connecticut and Rhode Island, simply retain their colonial charters that they have resurrected from the Proclamation Act and snip off offending royalist provisions as they saw it and live with those as their constitutions into the 19th century. And why that's important for our story is that those state constitutional provisions on religious freedom are an important part of the raw ingredients that inform the work of the first Congress. All of those states have in place robust freedom of religion or liberty, freedom of conscience or liberty of conscience provisions. And those provisions are understood in the day and discussed in the Constitutional Convention and ratification debates to entail three basic things. One, that religion is voluntary. It can be changed, it can be chosen, it can be rejected, it can be altered without encumbrance by the state. Secondly, that conscience has to be free from coercion, direct or indirect coercion by state power to force a person into a particular form of faith. And then third, controversially, but in many of the states, liberty of conscience also entails exemptions from general laws that violate the core tenets of conscience, especially in areas like pacifism, conscientious objection to military service, conscientious objection to oath swearing, and sometimes to tithe payments as well. Every state has some kind of free exercise clause or freedom to exercise religion, which is viewed as both an individual and a corporate right. Sometimes it's restricted to free exercise of religious worship. Oftentimes it's free exercise of religion more generally, without restriction to worship alone. Many states have provisions in place that protect against religious discrimination. It was called molestation on account of religion and belief in the day, a kind of general equality provision that is in place pretty widely amongst the new state constitutions. 5 of the 13 states prohibit establishments of religion by law. The fixing, defining, settling by law of religious doctrine, religious canon, religious text, religious practice, that is prohibited in 5 states, but 7 states explicitly protect religious establishments in their individual states, and 4 counties of New York do the same thing. And those are provisions that oftentimes manifest in the preferencing or favoritism of one form of religious faith over all others, Anglicanism and eventually Episcopalianism in the South, Congregationalism or Puritan Calvinism in the North. The favoritism manifests itself in special use of those religious organizations and their officers for getting state things done, favoring them for charity and education, for incorporation of their bodies at law, sometimes collecting religious tithes by the state for their maintenance and use, applying religious test oaths generically or sometimes quite specifically, and in turn putting disabilities, not ultimately crushing disabilities, on religious nonconformists, making it more difficult for them to get schools and charities, putting limits on the acreages of their properties, making it harder for them to be incorporated at state law and the like. Alongside these 13 states whose constitutional provisions on religious freedom are an important part of the raw material of the first Congress that crafts the First Amendment, we have a provisional national government, which starts already in 1774 during the buildup to the Revolutionary War, organizes the war effort and the diplomatic exchanges that are necessary for its proper execution, and becomes the provisional national government atop the 13 individual states. It gets weaker and weaker from 1776 to 1789, in part because there's no formal constitution, in part because there's no federal judiciary to enforce its laws, and importantly, eventually, there is no taxing and spending power to get things done. But the Continental Congress, notwithstanding its waning power from 74 to 89, does a number of things on religion and religious freedom that are going to become important parts of, again, the raw material of the first Congress. They hire chaplains for the military and legislative chaplains to serve and open every session of the legislature itself. They issue Thanksgiving Day proclamations and special prayers at given times of the calendar. They allow for interstate commerce of religious articles to be free from taxation. They insist upon the creation of an American edition of the Bible, ultimately not funded, but nonetheless put in place. They provide for funding for missionaries and on the frontier and for seminaries that train those missionaries for the frontier. And they have a lot of language in their various treaties and agreements with merchant soldiers and with foreign lands guaranteeing religious freedom, oftentimes in robust terms, and on the frontier in the territories providing religious freedom protections as well. The system of 13 fiercely independent states operating robustly with their own state constitutions, and the national government provisionally put in the Continental Congress's hands begins to break down in the 1770s and 1780s. And ultimately, the system doesn't work. Part of the problem is that some of the individual states begin to create their own bodies of law, their own diplomatic relations with foreign powers, their own postage, their own currency, begin to home rule in favoring intra-state litigants over foreign litigants in basic cases, especially things of inheritance and contracts and the like. They begin to raise their own armies and put in place a number of difficult provisions with respect to those, especially with respect to foreigners. And the gradual system of comity and fairness that was in place during the Revolutionary War breaks down, violence breaks out. Shays' Rebellion in particular is emblematic of what eventually becomes clear is that there's a need to create a federal constitution. 1787, 55 delegates from the 13 states get together to craft the Constitution, and the Constitution that comes forth is long on power and short on rights. Long on power, and that the Article 1 elaborates legislative power. Article 2 does some with executive power. Article 3 does even less with judicial power, having no national judiciary on which to call for experience, but a bit on interstate relationships, but very little on rights. We have in Article 1 a bit on no bills of attainder, no ex post facto legislation, habeas corpus, an important right, but nothing else. And the states, when they received this Constitution in order to have it ratified, asked where the other half was. We can ratify this instrument, ultimately, they said, they agreed, but only on condition that the first Congress be deputized as its first priority to craft an independent Bill of Rights and to have that independently ratified by 9 of the 13 states. And that was the condition which the Constitution went forward on. And it's in that context where we come to our story, more specifically on these drafts of the religion clauses. Because the first session of Congress has as its business to craft a omnibus Bill of Rights, and in particular to include in that omnibus Bill of Rights provisions on religious freedom. Obviously, the representatives and senators who come to the first Congress aren't starting ex nihilo. They have all their state constitutional provisions and experiences. The more learned ones, see John Adams and James Madison and the like, know about the history of rights and liberties in the Western tradition. Adams has just put out his 3-volume defense of the American Constitutions, which goes back to biblical and Roman times to tell the story of rights and liberties and what they mean. There is a powerful set of experiences and documents that are already part of the arsenal of what the first Congress has. And then in addition, the state ratification debates, the state ratification conventions, in their debates, craft drafts of clauses that they think are appropriate for religion. And it's the first 10 of the 25 that I have on that appendix, which come out of that set of recommendations from the state ratification conventions that I want to gloss a bit, because they're part of the raw material that the first Congress starts with, especially. And if you look at those first 10 provisions, which I'm going to turn to a bit nerdily as we go along, the first thing that you see is a deep concern in drafts 1, 2, 4, and 6 about this new national government fooling around with religion at the state level, interfering in what the states are doing or creating national establishments. There's a deep concern that that is one thing we want to avoid at the national level. This powerful new body that we've created atop the sovereignty of the people and the sovereignty of the individual states cannot encroach on what the states are doing and cannot put in place a national constitution, is what the import of those provisions are. The first one identifies all 3 of the branches of the new government, executive, legislative, and judicial alike, but the focus increasingly is on the most dangerous branch, Congress. And if you look at draft number 6, you'll see that New Hampshire, in the form of Charles Livermore's work, focuses on Congress. Congress shall make no law touching religion or infringing the rights of conscience. That concern, the Federalist concern, is deeply ingrained in these early interventions and recommendations. Second thing that we get is a very strong emphasis on liberty of conscience, as the state constitutions themselves had given us. There is an insistence on protecting freedom of conscience in general. You see that already in number 2, and it continues throughout the different drafts as a generic concern to make sure that conscience itself is protected. 20 of the 25 drafts are going to have conscience protections in place. Interestingly, we'll see in a few minutes, not the last draft that becomes the Constitution. And then also a concern for protecting 2 kinds of conscience rights, freedom from being forced to bear arms, conscientious objection for pacifists. Number 3 and 10 pick that up. And then in number 5 and 7, you see concern for protection for people being forced to swear oaths. And the context of that is important because the exculpatory oath or the loyalty oath was an important instrument for defining who's in and who's out of the realm of conformity. And the oaths in general are viewed as one of the kind of core places where people need to abide their basic biblical command. Let your yes be yes and let your no be no. Do not swear oaths before men, a kind of basic biblical maxim that Quakers and Moravians and a few others took very seriously in the day. Third thing I want to point out in these provisions from the states is version number 8, which comes out of Virginia, informed by the Virginia Declaration of Rights. And here we have a few interesting features that are worth lifting up. One is, this is the first and only place where we have an attempt to try to define religion. Religion is the duty that we owe to our Creator and the manner that by which it is discharged. That kind of focus on religion being a right to do one's duties, and the duties themselves being anchored in a creator God, a deistic or theistic framework being essential. Secondly, a focus on religion having a 2-dimensional quality, religion being the dictates of conscience and the natural, unalienable, equal right to exercise the dictates of conscience, the freedom to exercise according to the dictates of conscience. Third, a very strong emphasis upon it's not just anything. It has to be grounded in reason and conviction. You see, hear the language there, right? Religion can be directed only by reason and conviction, not by force or violence. And the fourth is this last provision, which we're going to call the non-preferentialist provision. And that talks about no particular religious sect or society can be favored or established by law in preference to others. Religion generically may well be favored, but certain kinds of sects or societies, picking out the Anglicans or picking out the Presbyterians or picking out the Congregationalists for special favor, no longer is permitted. They're all for establishments generically, but they're not for preferential establishments, is one of the takeaways from that ultimate provision. And that same version number 8 gets repeated in number 10, and in number 10 added to it is another version of this concern for conscientious objection to military service. And the only other thing I want to point out in this collection from the states is number 9, where we're going to see this funny phrase, free exercise of religion, unpacked a little bit. Free exercise of religion goes back to Roman law. Julian can fill us in, but the Edict of Milan becomes the one place where it's particularly prominent in the mind of the founders, and it comes back repeatedly in 16th and 17th and early 18th century texts. And free exercise of religion is kind of the term, but New York spends a little time unpacking that. It's the equal, natural, and unalienable right freely and peaceably to exercise religion. That's what's at stake. Free exercise of religion is something that is a shorthand for this more elaborate understanding of the freedom to exercise. And we're going to make some hay of that in a few minutes as we look at the final crafting of the clause. So that's what we get out of the states. And that, together with the state constitutional provisions and the colonial and European history, is what the first Senate and the first House have at their disposal. And it's that which gives rise to the discussions in the states about what ultimately do we want to have the First Amendment become? What do we want the religious freedom provisions of the Bill of Rights to look like? Here we've got a problem because we don't have a good record exactly at a place where we would want to have this important document as it's emerging have a full sense of what the debates were about, a full sense of what the congressional record says, a full ability to kind of understand the ethos and the nuances of the debates back then. We don't have one. We don't have a Annals of Congress in the first year. It starts in the late second. We don't have an official record at all. What we have, and that what comprises the first Annals of Congress, is a set of notes taken by a reporter, Thomas Lloyd. And he reports only for the House, and the Senate, we're going to see, like the Parliament, is closed doors, and all we get there is a logbook. And God bless Thomas Lloyd for giving us what we have, but there's a few problems. Problem number one is Thomas Lloyd didn't show up for work every day. And we have gaps in his notes, day-long gaps in his notes. Number two, Thomas Lloyd couldn't always hear so well. And sometimes he's kind of guessing as to what he heard. And here and there we get ellipsis. Here and there we get his putting 2 or 3 alternative words. He wasn't sure what he heard in the record. The third thing we get is Thomas Lloyd liked big lunches. And he liked, I think, 3 martini lunches, because oftentimes the notes in the afternoon were much more cryptic and much more sloppy than the notes in the morning. And occasionally, Thomas Lloyd fell asleep. I've seen his actual notes in the Library of Congress, and there you can just see his pen sometimes fall asleep, and then he's picking up the story 10 minutes or 2 hours later, God knows. Oftentimes it's a kind of a sad afternoon when we're looking at Thomas Lloyd's notes. But at least we have that, and I've given you in this article every molecule that's left from Thomas Lloyd's notes. What we have is a bit of an antiseptic version. Antiseptic in the sense that when the Gales and Seton put together the record, they asked the representatives in the House whether this represented what they said. And here and there, some representatives got very aggressive as to what they actually said compared to what was actually in the notes. And we're not sure whether they are engaging in their own kind of self-correction, making themselves sound to look a little bit better, making adjustments. We have several instances where we're just not sure what they said before. We know what they wanted themselves to say. And in addition to that, we have basic editing that goes on. And if you look at the text that Thomas Lloyd gives us in his written version and the actual printed text that we have at our disposal, it's about 85% of being identical. There's some changes being made there, and the editing is sometimes a little bit questionable. So all that to say, here we'd look to have better records than we have. Well, at least we have some. And when we get to the Senate, we have only a logbook. Motions made, passed, defeated, nothing more. And when we get to the House and Senate debates at the end, we have, in the style committees, we have nothing. So let's see what, with that context, let's see what we have here and see what James Madison, skillful politician, tries to do in version 11 and 12. He tries to split the difference from what he heard from these 10 ratification debates at the state level. He says, why don't the focus is really concerned about national establishment, so we're going to prohibit a national establishment. The concern is really about freedom of conscience And so he puts a generic freedom of conscience provision in 11 and then adds in number 12 an additional conscience provision that binds the states directly, with an understanding that the federal courts are now going to be in the business of making sure that no state shall violate the equal rights of conscience. There's a very heavy emphasis on conscience at the generic level and a specifically binding provision, and then no national establishment. It gets nowhere, doesn't get discussed, doesn't get mooted, ultimately gets delayed for 6 weeks before we come back. Madison pushes hard to have his provisions again reconsidered. He gets put in charge of a committee of 11, and we get 13 through 15, the drafts that are the committee of 11 gives to us. And now what he's doing is interesting. He's saying, well, why don't we make the no establishment of religion passive voice, make it a generic guarantee, make, again, liberty of conscience generic guarantee, like the rest of the Bill of Rights is going to be. There shall be no illegal searches and seizures and the like. And then, again, underscore that states, again, can't infringe rights of conscience. And he puts that in place and then adds a particular concern about conscientious objection to military service and gives a special conscience claim to the religiously scrupulous about bearing arms. That too gets nowhere. It's debated, it's criticized, and ultimately what the House comes to in version number 16, which we're back to number 6, Congress shall make no law touching religion or infringing the rights of conscience. The focus now again is on the federal government, not the states. No passive voice anymore, no generic guarantee that the federal courts might use to test what's going on at the state level, no worries about the national government more generally. The focus is now specifically on Congress. And that focus continues for the rest of the drafts. The deliberate attempt to bind the most dangerous branch of this new national government that's been put in place. And you see what Livermore's doing. No laws touching religion. That's the idea. Just don't do anything on religion and leave it to the states to do things and leave it to the private conscience to work things out for themselves. That moves back and forth in the debates until we get version number 18 and 19, which seem to have become the final version that the House wanted to put forward. And here we get a pretty clean, neat, three-legged stool on which religious freedom sits. Congress shall make no law establishing religion, or to prevent the free exercise thereof, or to infringe the rights of conscience. Focus again on Congress, but now no establishment, free exercise, and rights of conscience sit side by side as the foundation on which constitutional religious freedom should be guaranteed. And then we get a rider, no religiously scrupulous person shall be compelled to bear arms as well. That, for no explicable reason, gets reduced in version number 20 as the final House version to say, now Congress shall make no law establishing religion or to prohibit the free exercise thereof, both binding on Congress. And then this last provision, which now gets put in the passive voice again, with ideally capturing the pacifists concerned, nor shall the rights of conscience be infringed. That's the last version coming out of the House, and that goes to the Senate for its conversation. And the Senate, in its conversation and debate, which we know nothing about, in part because we don't have even a Thomas Lloyd, but in part because this is the upper chamber. And this is viewed the old ethos of, look, the upper chambers, like the Parliament, like the House of Lords, and specifically, is in the business of private conversation, advising the sovereign as to the best law, having the free speech rights to engage in robust debate, understanding that this was entirely left internal to the body, but the openness of the debate came at the cost for us as historians of what they actually said. And so what we get instead is an attempt by Congress in the Senate to specify a little more clearly what they want to put in place in the First Amendment. And you see, much of the effort is focused on nuancing what the Establishment Clause is about, not establishing a particular sector society in preference to others, not establishing particular forms of faith or articles of faith, attempts to explain exactly what features of establishment are worrisome, and at the same time, ongoing concerns for freedom of conscience. And in the end, sneaking in without a lot of conversation in drafts 23 and 24, a sudden concern again for free exercise of religion. But ultimately, what we get in draft number 24 is two of the three legs of the stool of religious freedom that came out of the House. Congress shall make no law establishing religion or prohibiting the free exercise thereof. And that's what goes to the House and Senate Style Committee for conversation. They seek to work out an understanding that both sides could agree to, and the ultimate draft that we end up with is close to that. But now it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And what's new in that language is a respecting provision. Not Congress shall make no law establishing religion, is Congress shall make no law respecting an establishment of religion, and we're going to have a little fun trying to figure out what that means. So that's a hopelessly nerdy recitation of the different drafts that we get. And we're now left with trying to figure out, well, what ultimately does that mean? What were the founders trying to do with that language that ultimately gets ratified by the 9 of the 13 states? What plausibly can we impute to that final version? And I've suggested to you there's a thinner reading and a thicker reading. The thinner reading is one that says, look, all we have here is an outline, an agreement upon the extremes. Congress shall make no law prescribing religion, establishing religion, and Congress shall make no law proscribing or prohibiting the exercise of religion. Those outside extremes are prohibited and governed, and everything else is left for constitutional development. That sounds minimalist, but in the day, that's pretty impressive. Saying that the new national government can't be in the business of establishing religion, fixing and defining and settling by law one particular form of faith is new. Everyone in Europe at the time has established religions in place. There's established Anglicanism, the Church of England, established Presbyterianism in Scotland, established Lutheranism in the Nordic countries and the Northern Empire, established Orthodoxy in Greece, established Catholicism of various sorts in France and Spain and Italy and Poland. Establishments of religion by the national government are normal. And the Westphalian Settlement in 1648 sets that up. Quis regio eius religio. The religion of the ruler is the religion of the land. That idea is normal. And all of a sudden, here comes this upstart colonial group that says, not at the national level. Maybe at the state level with some diversity, but not at the national level. And secondly, Congress shall make no law prohibiting the exercise of religion. That too is major and a major move deliberately in the day. You've got to remember that it's normal to have one form of faith in the territory and then grudging toleration, if any, of all other forms of faith. And the issue is how much you are going to condition the presence of those others in your polity. This is still before the Catholic Emancipation Act of 1833, before the Jewish Emancipation Act of 1858 in England. And England has deliberately an established conformist, a tolerated Protestant minority, and then at best grudging acquiescence in the presence of, but with no real constitutional rights attached to these other groups. And the same thing is true in France. Exactly at this time, France is going through its revolution. France is decimating the Catholic Church, which it had historically favored. taking much of its art, much of its architecture, killing its priests and its monks, driving much of its hierarchy out by the tens of thousands, having done the same thing a century before to Calvinists after the revocation of the Edict of Nantes. National governments being in the business of prohibiting groups altogether is normal in the day. And what this provision says is not on our watch. So that minimalist understanding helps us kind of think of one set of ways of reading the First Amendment, which is it sets loose a constitutional process with some guardrails. And what I do in the rest of the article is to say, well, you might be able to do more with that language. And let's kind of parse that language the way that the U.S. Supreme Court and lower courts are going to have to do when they try to make sense of it in the 266 cases that the Supreme Court has heard in making that language real and applying it. Congress, the focus on Congress is clear. And this is a deliberate attempt to bind and limit the national government, and especially at its most dangerous branch. We saw that concern from the very start, and that concern is manifest clearly in the deliberate choice of language focusing on Congress. Not passive voice anymore, like the rest of the Bill of Rights through 2 through 9, not passive voice as was contemplated in some of the earlier drafts. The focus is deliberately on Congress. This is a federalist guarantee. The national government is bound by the First Amendment, not the state or local governments. Secondly, Congress shall make no law. That's funny language. It's imperative language, obviously, third person imperative. And it's not clear whether Congress shall make no law altogether or whether Congress shall make no law that violates these exterior guardrails. There's a push in Congress, manifest in draft 6 and 16, that Congress should do nothing on religion. Don't touch it at all, that idea. But the reality is that the Continental Congress, as we saw, did do a number of things on religion, and the first session of Congress does exactly the same things. The first session of Congress, while it's crafting the First Amendment, also appoints legislative chaplains, 2 of them, a Presbyterian and an Episcopalian, $500 a year for each of them. That's serious money in the day. They're appointing military chaplains. They are continuing the discussion of the official American edition of the Bible. They're appropriating funds and driving them to the seminaries for training of missionaries. They're guaranteeing again no tax on interstate commerce and religious articles. They are repeating the Thanksgiving Day proclamations. They're repeating the religious language of religious freedom in treaties, as also the Northwest ordinances. So the Congress is making law, but it's not making new law in the first session. And one way to read that Congress shall make no law is you can make law as long as they're laws that we already have, that kind of old-fashioned way of ratifying old colonial practices. But the reality is in the next year, Congress starts making additional laws on religion that don't have antecedents in the Continental Congress, and many of the same representatives and senators are there. So it's pretty clear Congress can make law on religion as long as it doesn't prohibit free exercise or establish religion. And then we come to the Congress shall make no law respecting an establishment of religion. And the problem we have with this formulation, unlike the ones that we saw 18, 20, and 25, is that this language has this funny word respecting that's added to it. Congress shall make no law establishing a religion, we get it. But respecting an establishment, and as Thomas Lloyd puts it actually in his notes, respecting the establishment of religion, we have a much more fuzzy provision. And if you go to Samuel Johnson's dictionary or the Stroud's dictionary or other late 18th century dictionaries in the day used on both sides of the Atlantic, respecting means regarding, it's giving respect to, or reflecting. All 3 primary definitions, all 3 perfectly useful. And so now we go to, well, what does that respecting language actually do? And 3 possibilities. Congress shall make no law regarding those state establishments of religion. 7 of the states still have established religions. 4 counties in New York still have established religions. And at the same time, ironically, Virginia has passed Thomas Jefferson's bill for the establishment of religious freedom. The last thing that we want Congress to do is to make laws about that. That's one way of reading it. And that's going to be Justice Thomas's favorite way of reading it. This is about protecting federalism again. Second way to think about the respecting language is Congress shall make no law regarding, respecting in the sense of reflecting those, being redolent of those old establishment patterns. And there the thought is Congress can make laws on religion as long as they don't look, smell, or feel like classic establishment patterns. And the best poster boy that was put up for the debates in both the Congress as well as in the state ratification debates afterward is the Anglican establishment on the eve of the American Revolution, right? Where we have a supreme head of the church, which is the crown, who's also the defender of the faith, where we have bishops in the House of Lords, where we have Parliament or Convocation or both giving us the 39 Articles of the Faith, giving us the Book of Common Prayer, giving us the authorized version of the Bible and censoring all others, engaging in religious test oaths, collecting religious tithes. That collection of goodies, the first session of Congress simply would not accept. And nobody was arguing for that. And the question, if you had a law that reflected that old pattern of establishment, the argument becomes that's not appropriate. But you can do a lot of other things short of that about religion. That's perfectly fine. And indeed, Congress did. Legislative chaplains, military chaplains, tax exemption, and all the things we just talked about. So the thought is that's not an establishment of religion reflecting the old establishment. That's okay. And then the third reading is Congress shall make no law that moves in the direction of, is a step on the slippery slope toward achieving an establishment of religion. A much more careful prophylactic measure of making sure that it's not the nose of the camel under the tent business that we're trying to protect against. And there the thought is, well, the most glaring example of that is when you prefer one religion over another, one sect, one society, one set of articles of faith. If you start doing that, that's a step on the slippery slope that we want to avoid. Respecting an establishment. It's not clear. 3 plausible meanings, all of them can be defended on the record that we have, thin as it is, and each of them has borne progeny in U.S. Supreme Court jurisprudence in the 19th and 20th century. Finally, Congress shall make no law respecting an establishment of religion. We'll talk about that in a second. The religion definition, or prohibiting the free exercise thereof. And that's a much more problematic provision. It's a problematic provision in part because of this seemingly very narrow word, prohibiting. Congress can't prohibit the exercise of religion. Okay, but can it abridge it? Can it infringe it? Can it violate it? Can it coerce it? Can it prevent it like the other drafts had said? Or is it just a really extreme protection against really extreme measures by Congress like the French were doing to the Catholic Church in the day? Is that all that's being done here? Why such a narrow definition is the question. Secondly, what's in the free exercise clause that's not already guaranteed by the 3 other clauses in the First Amendment, which are protecting free speech, free press, and free assembly. And we know that language being drafted at the same time as the religion clauses include free religious speech, free religious press, free religious assembly. Those 3 clauses already protect those dimensions of religion. And the question then is, what does the free exercise clause guarantee that's not already protected by those 3 other guarantees in that same First Amendment? These guys were not in the business of doing redundancy. The thought is now there has to be some independent conduct to free exercise. And then the third is, where's the conscience clause? Where is the conscience clause? That most important of the clauses in the earlier drafts, 20 of them, talking about conscience, freedom of conscience generically, or talking about specific kinds of conscience claims, especially for pacifists and oath swearers, it drops aside. And the power that liberty of conscience provisions gave to the founding era was protections against violations of voluntarism, protections against coercion, and protections of exemptions from laws that were potentially the tyranny of the legislative majority. And those are missing from that guarantee and that well-understood understanding of what well-understood version of what freedom of conscience means drops out in the final draft. And so can we read, the question becomes, can we read some of those concerns that liberty of conscience by itself historically gave us? Can we read that in a way that would include those same kind of concerns that the state constitutions give us? And that's a hard sell. There's a way of saying that if there's an a fortiori argument, right, if you're going to protect the free exercise of religion, a fortiori, you're protecting the liberty of conscience that gives rise to, that provides the dictates and duties that conscience teaches. But that doesn't answer why we always had free exercise and liberty of conscience side by side in the earlier drafts or in the state constitutions. You can say that, well, conscience is something that we read into free exercise when it's elaborated the way that New York does in the draft number 9 that I pointed out. It's a natural, equal, and unalienable freedom to exercise one's faith. And the argument then could be, well, maybe what we have to think about is the freedom to exercise one's faith can be a freedom of action or a freedom of foregoing action. Because we all know that, for example, in criminal law, the actus reus requirement is the voluntary act, killing someone, or the voluntary omission when there's a duty to act, failing to rescue your spouse when she's been shot or he's been shot. And the thought then might be freedom to exercise, freedom to act on the dictates of conscience can be action or it can be omission. And you can think about freedom to exercise in that version number 9 understanding of free exercise as maybe having implicit within it the freedom to forego action and having that respected. But that too is a stretch. A third might be to say, maybe the focus should be on the unalienability of this. The focus on rights that cannot be given away, can't be taken away. Unalienable rights, if they can't be taken away, don't need to be guaranteed because they're naturally guaranteed already. And maybe that's what the omission is about. But none of those is an easy sell in terms of interpreting the final words that we get. We can maybe make a little bit more of the narrow language of prohibition when we read with Michael McConnell the thought that prohibition, prevention, abridgment, infringement in the First Amendment are really in many ways synonyms, trying to keep it spicy. But that too is a pretty hard textual sell to make. The free exercise clause doesn't do the hard work that it does in tandem with other guarantees in state constitutions and doesn't capture the full concern that the ratifying conventions and the House and Senate debates seem to have about that guarantee. We have a clear indication as to why one of the versions of freedom of conscience gets dropped from the Constitution, and that is the concern about conscientious objection to military service. And there we have some concerted debate twice in the House that survives to us, and it's echoed in state ratification debates that say exemptions for pacifists have to be done by the legislatures. and not by the courts. And if done by the legislatures, they can take the full record into account. They can take the full interest into account. They're not bound by the judicial record that binds a court. And maybe better to leave accommodations and exemptions to the legislature. And that becomes a foundation for one streak of interpretation made famous by Justice Scalia that says, look, if you're going to do exemptions for religion, you have to do exemptions legislatively, not judicially. This should be in the hands of the bodies that can collect all the data and make judicious interpretations. But in the 18th century, the real concern was the tyranny of the legislative majority. And the legislative majority is not in the business of trying to accommodate odious groups that came along, and religious hatred was a normal part of 18th century calculus, and Quakers in particular didn't do so well. Moravians didn't do so well. Upstart faiths didn't do so well in state legislatures or even in Congress. And so and let alone Native Americans or African Americans and others who were enslaved. And that raises the last thing, and I'll stop in 2 minutes so we can start conversation. What do they mean by religion? No establishment of religion, no prohibition, the free exercise thereof, that is, of religion. Except for draft number 8, which tries to give us a definition of religion. We don't get one from the House or Senate debates. When they're discussing religion, they understand there's a category of religion and a category of non-religion. They understand there's a difference, that the religion clauses are binding people that are religious, and the free speech, press, and assembly clauses can be made available to those who are non-religious. They understand that. They mention Quakers, they mention Moravians. But if you listen to the discussions in the state ratification debates about the religion clauses, folks are rather concerned to protect Protestants, first and foremost. Some generous ones will say Christians. Occasionally we'll hear about Jews. Occasionally we'll hear about Mohammedans and Hindus. But nobody in the day is advocating for the rights of Africans, especially enslaved, who bring their unique religions with them, Native American Indians, who are said to be not protected by the religious freedom guarantees. There is very much an 18th century kind of Christian American ethos reflected already in the notion that we could contemplate having an American edition of the Bible as just a normal way of doing things without trespassing establishment or free exercise norms. And so we're left with a text that doesn't have an automatic meaning, some things clear and some things not nearly so clear from the original materials that we have available to us. The 14th Amendment we're going to see in 1868 is going to do some other work, but really doesn't talk much about the religious guarantees of the day. And much of what we now understand to be First Amendment religious freedom jurisprudence, even that which is articulated by originalists, has a very hard time being anchored in the original understanding of what the religion clauses are about. Here endeth the sermon, and now the fun part starts, which is hearing from all of you. Thank you for your attention. Sorry to go on for a little longer than I expected, but the First Amendment is a topic of excitement. So, thank you.
Well, thank you so much, John. That was absolutely fascinating. I really did enjoy that. I will open up to questions now. And if you don't mind, just making sure everyone has their microphone off when somebody's speaking, just to avoid feedback. I will start out if nobody else has. No. All right. I will go ahead and abuse my commoner's privilege. I'm really curious about your opinion on the role of divergent state cultures and colonial cultures and how they kind of grew up from, not to get into seed theory or anything like that, but how their origins and how they developed over the colonial and early period, kind of leading the Constitution, and how those different kind of cultural approaches to the free exercise of religion, or to any really of these these provisions that have multiple means of analysis, multiple ways of understanding them, might have interacted. Would you say that, especially given the kind of Virginian definition of religion, it seemed to almost, if not be taken for granted, it seemed to be the only one, as you mentioned, that was even advanced? Madison's role in all of this, the Virginian kind of emphasis on free exercise of religion. Was there an argument to be made that this kind of Virginian approach might have won out in the eventual understanding? And if not, would you say that you could kind of attribute any of these different means of analysis to different arguments advanced by states?
So there's a lot in that. One is the just empirical question about what's going on in the colonial period on the eve of the American Revolution, and how much diversity is already there in the way that colonial powers have understood religion and religious freedom. So there's three large approaches that I think you can point out. One are strong establishment approaches, which we see in the New England states, Massachusetts, Connecticut, Vermont, the kind of very strong emphasis upon the state being in the business of fixing and defining and settling by law what the religion is, collecting tithes, administering religious testos, being churlish about the delivery of charity and educational charters to the nonconformist, being overt about the religious character of the polity, insisting upon educational institutions fostering religion, morality, and Christian understandings, basic understandings of moral agency. Having religious testos that are applied sometimes with Trinitarian exactitude on especially governors, lieutenant governors, and high court judges, sometimes with litigants more generally, people probating wills and the like. So there is a kind of hard establishment pattern there that obtains in the New England states, and there's echoes of that, I think, in the South Carolina, North Carolina, certainly in Georgia, and before the Virginia moves that are made in the 1770s and early 1780s in Virginia as well. That hard establishment pattern is one that is jealously protected by the Federalists, who want to ensure that their way of doing things in their individual states can continue. And this is the vestige of wars of religion in Europe, where each of these powers is not only seeking to extend its territory, but it's also seeking to extend its church, whether a Lutheran church or an Anglican church or a Presbyterian church or a Catholic church. There's a very, very deliberate attempt to imprint upon the colonial world their particular brand of faith, and to insist upon that being a fundamental ingredient of the common good in the day. Secondly, there are what are called pluralistic establishments, or much looser establishments that allow for the state to prefer religion generically, sometimes to single out certain forms of faith and to give them a little more preferencing. But for example, what we get in Catholic Maryland in the 1630s and 40s, and what emerges when England takes over, is a kind of a poly-religious quality where everyone is allowed to coexist with a pretty strong measure of toleration. There is a strong kind of protection given to freedom of conscience, an attempt to accommodate different forms of worship, even if the state may still put its thumb on particular forms of faith. It does that with far less exclusivism than obtains in New England and some of the southern states. And then the third are these very strong new experiments in no establishment of religion and freedom of religion for everyone. And Rhode Island, by Roger Williams's day in the 1643 and 62 charter, and Pennsylvania in the 1682 Quaker-grounded charter, are two early examples of saying, we are going to experiment with this idea of no establishment of religion. We're going to experiment with giving religious freedom for all. We're going to welcome every form of faith, and we're going to celebrate pluralism as a good rather than as a pollution on our pure local polity. Each of those kind of hard, soft establishments and then non-establishment patterns, you can find when you start looking at the local or county level. You can find echoes of them too. New York is the best example, where 4 counties are kind of hard, old, English, and then before that, Dutch Reformed establishments that persist. But then in many other parts of New York, the local polities kind of go their own way. That's an accident of what colonial charter life is like. But we get an awful lot of diversity there. The consequence then of all of that is that when people use terms like liberty of conscience or free exercise of religion or religious equality or religious pluralism or separation of religion and state, they have quite different views of what those particular terms mean. And when they talk about disestablishment of religion, they also have a particular way of thinking about it. It can be hard establishment, disestablishment, or soft disestablishment. Separation of church and state can be dividing religion and politics altogether, Jeffersonian style, or it can be a much softer, making sure these two offices and officers can maintain their own individual polities and without the interference of the other. When they talk about religious pluralism can be, well, we're going to welcome all Protestants or all Christians, but not Jews and not Muslims and not Native Americans and not African American slaves. Pluralism can be collectively everything, or it can be much smaller. Equality is in the hands of in the eye of the beholder. It's a guarantee that's not absolute equal, but it's an invitation that everybody has an equal right to be there, even if they get treated a little bit differently. So the language, the principles of religious freedom, even if they're common across the 13 individual colonies and eventually states, are freighted with different kinds of meanings, given the experience in which these folk come, and sometimes the European antecedents on which they're calling. And so when a term is used in the constitutional text, you got to be careful, because if you ask somebody sitting in Boston with a hard Puritan Congregationalist ethos, he or she's going to have a very different view than sitting in Charlottesville or in Richmond and trying to kind of think of with Thomas Jefferson about what they're meaning. I don't think you can make the case that the Virginia version triumphed. Justice Black would like you to believe that in the Everson v. Board of Education case, but there are 13 individual states, each of which have their own distinctive histories, and none of which, I think, is the template or the transcript on which the First Amendment sits. And I think one of the goals of historiography in the last 2 generations has been, contrary to Everson, to try to collect much more generously and generically from all the different state experiences to make a more studied attempt to impute to what those final 16 words are really about. What's a plausible range of meanings? And what you're getting in my work is an attempt to, gather 40 odd years of that history and kind of put it together into a case for pluralistic interpretation.
Well, thank you. That's fascinating. Kind of, ask some questions about the Virginian dynasty and whether that may have colored our kind of historiographic over the past few generations, or perhaps earlier understanding of how these processes evolved. Can I open up to any other questions? Oh, Julian?
Thanks very much, John. As you were talking about the European experience of establishment and the unusual nature of the United States experiment, I was reminded of the Act of Union with Scotland in 1707. And because there, of course, we have an example not just of personal union embracing a diversity of religions, but a political union in which there's an imperative to secure distinctive religions within the one new political unit. And I just wondered, is there any evidence that that precedent played any role in the thought of the founding fathers? Were they mindful of the fact that many of them had come from a kingdom that embraced 2 different religions and secured that by law in treaties and acts which might have been viewed as fundamental then? There's obviously a big debate about that, but anyway, it's a precedent for a form of plural establishment in the 18th century, and it would be interesting to know if that had any resonance whatsoever.
It certainly did at the state level. And the idea, especially in the soft establishment world, the Act of Union in Scotland, the Union of Utrecht in the Netherlands in 1579, some of the Swiss cantons and the kind of confederation of different ways of dealing with multiple religions, the experience of the imperial city-states in the Holy Roman Empire after already 1555, but certainly after 1648, which were exempt from insistence on either Lutheranism or Calvinism or Catholicism, but could have multiple religious communities sitting side by side with the providence and protection and sometimes patronage of the city councils. All of those examples were known in at least the more learned hands in the American founding era. Thomas Jefferson certainly knows them. James Madison knows some of them. John Adams is probably the best informed of these things. John Witherspoon, certainly coming out of Scotland, knows about the Act of Union. So there is a recognition that multiple religions can coexist in a community to the good of the community rather than to the impoverishment or to the imperiling of the community. And that sets the stage for an increasingly strong argument about the good of religious pluralism altogether. And what you begin to see, as I say briefly in the first part of the article and elaborate more in the book from which this is drawn, pluralism becomes something that is celebrated rather than something that is condemned. And religious pluralism is viewed as a good, a theological and a political good. It's a theological good in the sense that it's much better to let 1,000 flowers of religion bloom and let God decide, rather than any human agent decide which of these forms of religion should flourish and which of them should fade. It's a abdication to the sovereignty of God over conscience, but also over the community, and recognizing that plurality of forms of faith is something for God ultimately to engineer in a different way if God wishes. That theological argument starts also getting some homiletic support, because we begin to see sermons in the 1700s, excuse me, that begin to start playing with the post-resurrection story and arguing that, look, when Jesus rises from the grave and all the different ways by which he's experienced, Mary has to be called by name before she recognizes Christ. Before that, she thought he was a gardener. The men from Emmaus can walk and talk about religion all day long, but recognize Christ only in the lifting of the host, in the Eucharistic moment that attaches. The disciples huddled in the room don't recognize Christ. They think he's a ghost until he breathes his peace on them. St. Thomas needs to have a tactile experience, an engagement with the Lord himself, and putting his fingers in the nail holes of the cross. And the idea of St. Peter, who was confronted with a miracle and forced to face a threefold cross-examination. The sermons of the day start using that story, that set of stories in the post-resurrection experience, as an invitation for pluralism. Some forms of faith emphasize the Eucharist, other forms of faith emphasize the personal calling, others are informed by Pentecostal and Holy Spirit, others engage in rational disputation, others of them have to have various kinds of cross-examinations, powerful experiences of conversion. All of those are viewed to be goods rather than bads, and in the post-resurrection era, celebrated rather than denounced. And then the second argument about pluralism becomes a political argument. Not only is this theologically the right thing to do, but it's also a good thing to do. And we begin to see that multiplicity of sects, as it was called, religious pluralism, as we would say, is a good way of creating a check and balance on any one particular religion getting the best of the polity. It's the best way to ensure that these traditions play what Thomas Jefferson calls the censor morum over the other, keeping the other ones at bay. And this becomes a variation on the argument in Federalist number 10 and 51 about the good of factions. Factions are good. They provide experiments. They provide different ways of applying things. They provide different kind of checks on the other. And out of that collection come certain generic political goods. And the thought here, likewise, is denominationalism, religious diversity is a good thing, because not only without the state, we still have built-in checks and balances, but we also have a kind of pre-Darwinian form of natural selection. The strongest religions, who do the best, who are vibrant and not dependent upon the largesse of the state, do best. And the weaker religions, who are no longer able to engage in the competition, are going to fade away. And that's viewed as a good rather than a bad. So pluralism built on those early examples, and there are earlier examples too, the Holy Roman Empire, the Roman Empire itself after the Edict of Milan. All these things are kind of lifted up as good examples of the way we're doing it in America is a good thing. And it's selective history, to be sure, kind of law office history, as we lawyers would call it, picking the precedents that work. But it's a thought to be and celebrated in pretty quickly as the best way to go. I dare say that hasn't changed. Even though we have these anti-Catholic movements in the 19th century, we have a very kind of anti-foreigner movement in the later 19th and early 20th century that begins to violate that kind of founding ideal. But it is baked into the DNA of American constitutionalism early on.
Open it up for any additional questions. Please feel free to either just start speaking or to raise your little online hand. Neil.
Thank you very much. I hadn't at all thought about that point about the post-resurrection appearances. That's very interesting. Could I ask you about, you mentioned at the end the question of the definition of religion, something which drops away, and you make a point about this is conscience. And this might be an equity lawyer's question, but I wondered whether you could say something about how conscience might have been defined or understood by those using the term in the context which you're considering.
Yeah, they're deeply informed by the Westminster Confession idea that the conscience is the sanctuary of the Lord. The Lord is the ruler of conscience, and that conscience is the place that receives direct revelation, direct inspiration, direct natural law predicates on which a person builds his or her life. Conscience in that sense is a very Christian idea. It's also a very Stoic idea that this is the place where God dwells to guide us in what we do. And it provides us with the starting point that then has to be implemented. They don't talk so much about synderesis anymore, but they do talk a lot about the operationalizing of the dictates of conscience, and free exercise becomes the shorthand way by which that is done. Secondly, the idea of conscience, and this is where the equity business, the idea that we have to live by the letter and the spirit of the law, that we have to live by the letter and spirit of Scripture. That idea of conscience is a common one in the founding era, and the notion of trying to live out the love commands, not simply by every jot and tittle of the law, but also by the generic love that we have for God, neighbor, and self, is an important way by which conscience is discussed, and particularly well positioned to prepare the Christian judge, the Christian equity judge in particular, to do equity in an individual case. That's an important consideration. And I think the third is the idea of conscience, reason, and conviction sitting side by side by side. And what I mean by that is that conscience is now viewed as the fuel by which a person develops his or her convictions, and that those convictions cannot simply sit generically. They require a rational application, explanation when a person is making a claim for a particular special good that attaches to his or her conscience, or a special application of a rule that, as a judge, they think is appropriate and expedient. This obligation of rationality, of explanation, is an interesting one in the 18th century that I don't see as much in the English discussions, although I defer to my distinguished colleagues here. It comes up a lot in the 1750 to 1800 discussions about, look, you can't just claim it as conscience and therefore you're going to be accommodated. Your conscience has to be sincere, conviction, and it has to be rationally grounded somehow. And that rational grounding can be by pointing to a scripture verse that you have to live by. It can be discussed as an essential part of your being that you think is important to you. But you're going to have to, you can't simply have a trump card that you can play by a freedom of conscience claim. There has to be some casuistic method by which you can explain it, or somebody can explain it for you if you don't have the ability. And I think those three ways, I think, is how conscience starts getting parsed out in the 18th century discussions that we have it. As you know, that's a much more complicated story as we move forward, and it starts to devolve into thought, into the freedom of thought, conscience, and belief that becomes a feature in 20th century international human rights laws. We don't have antecedents of that, so far as I can tell, in the 18th century American discussions.
Thank you.
Pleasure.
We have Julian. Please.
Julian.
I'm sorry, I can't find my electronic hand, so it has to be a real one. John, so one of the things I stumbled across not long ago was some discussion in the mid-18th century English case law on the Toleration Act. And I hadn't realized, and I don't know if you'd come across this, that in the early part of the 18th century, there was I think a predominant argument that the Toleration Act of 1689 was in fact a personal act. It did not make general law, but was personal to those groups it was designed to benefit and needed to be pleaded by the litigants before the judge. The judge could not be expected to take judicial notice of it as a matter of general precept. And it's, as far as I can see, only from the mid-18th century that the idea emerges that it reflects a natural right. It's that there is a natural right to freedom of conscience, as opposed to a process of indulgence or relief for tender consciences defined group by group, as you indicated, I think, correctly in your talk. You know, by Moravians, we'll accept them, we'll give them some relief because we're sympathetic, and so on through the different. You get this group by group basis done on a very much a sort of ad hoc basis, and the idea that you have a general natural right, as a pre-political right to freedom of conscience, which then plays through into the current law, is something which is still very new in the 1760s, let's say 1770s. And again, I wonder to what extent that plays a role in the debates around conscience. And you talked about how there was throughout the early drafts this insistence on conscience, but were there voices saying at any point, well, hang on a minute, this is not straightforward, precisely because of those reasons of worry that conscience is an unruly beast. It's sort of, you could claim anything potentially with conscience.
Yep. So good. Both the American story in the 1720 to 1780 records about what the 1776 records about what the Toleration Act means is exactly the same. That it is an individual right to be pled by the nonconformist who fits within the definition of the Toleration Act as it obtains in 1689 and is interpreted by British courts. That is the same way it's used in the United States, and it's precisely that feature which riles the founders in the crafting of the state constitutional, eventually the federal constitutional provisions, to say, we can't have that. You can't have religion be a legislative privilege that you gradually can have a indulgent court protecting. We should start with the opposite, which is every religion is presumptively given a natural right to exist and to worship and to practice and to enjoy freedom of exercise. And the only issue is what limitations can be imposed on it. That's a deliberate shift in the logic that the state constitutions already put in place, and that the federal constitution certainly also puts in place in the idea of free exercise for all. It's less about conscience and more about every faith presumptively has the free exercise right as an individual member and as a group qua group. The unruliness of conscience is certainly, the second point that you make, is certainly a deep concern. And we hear a little bit about it in the surviving House debates about the conscience claims of pacifists and the conscience claims of oath swearers. How are we going to know that they're true to their word? How are we going to be able to establish their veracity? What do we do with everybody that in the middle of a military conflict wants to walk away and not bear arms? How can we possibly protect ourselves? That concern is very much there. And it gives, I think, ample pause to the House debates, at least, probably the Senate too, about protecting constitutionally a conscience claim, which automatically gives a person a kind of veto on legislative decision making and wants to put those questions back before the people themselves and deciding who are going to have to bear the consequences of conscience run amok. Let them decide legislatively rather than letting a judge decide individually, case by case. I think what I said to Neil a little bit earlier about the tying of conscience claims to a rational demonstration of conviction is another epistemological way by which we try to keep conscience from simply becoming a license to become a law unto oneself. And that rational claim is something that you can see in some of the early case law. We don't have so much of it, but some of the early case law insists upon that in the state courts. And we hear the first rumblings of that in the U.S. Supreme Court in a 1862 case called Cummings versus Missouri, the first case dealing with a conscience claim about oath swearing that a Catholic priest raises in the middle of the Civil War. And what impressed the court and what they underscore in their opinion is there is a rational ground on which this guy is making his claim of conscience. He has explained clearly what his concerns are, biblically, theologically, philosophically, and politically, and we accept his argument as a consequence to be sincere and therefore one to be accommodated. There are earlier federal courts that do the same thing. Cummings is the case where the Supreme Court seals that kind of logic rather nicely. I think the one final thing I would say is that the far-seeing founders, Adams and Jefferson in particular, they understood that we may have a cacophony of different forms of faith, all claiming to be deserving of religious freedom protections. And if we have a cacophony of forms of faith claiming that we may eventually balkanize our laws by giving all of them the same generic right to make a claim of conscience, contrary to what the legislature might say. And Adams celebrates that. Jefferson puts a pretty strong caveat in place. And interestingly, it's Jefferson, the liberal, not Adams, the conservative, who ultimately says, this can't simply be a law unto oneself regime. It has to be done by legislative majorities. And let the legislature decide on claims of conscience and their veracity rather than the individual sitting before an indulging court.
Do we have any additional questions? If not, or while people are thinking of an additional one to ask, I might, if you don't mind, John, ask one more myself.
Yeah.
You had mentioned at a few points in the conversation that the concern was really focused squarely on Congress, on the legislative branch here. Yeah. And of course, this is before, Marbury versus Madison or the imperial presidency or any of these later concerns might arise. But if I'm not mistaken, it's only about a decade or so before Thomas Jefferson is being accused of atheism and his run for the presidency, for the executive office. And at a few points, comments kind of came up regarding, maybe I'm understanding this somewhat nebulously, but the kind of Christian responsibility of a judge in a court, there being a kind of religious imperative to act a certain way or decide a certain way. Obviously nothing that's established, but something that might have existed culturally. Could you speak to then the lack of concern in these debates around the judicial and the executive branches? It was just not something that they thought might be invoked by either of these two in the future. Was there no concern that a future president might belong to one of these religious groups that's not accepted under that formulation? Is that just not something that was pressing at that time?
It wasn't pressing in the 1760 to 1800 period. It certainly, as you say, comes up very powerfully in the Adams-Jefferson contestation that we get in when the Adams Party accuses Jefferson of being a Jacobin infidel and the Antichrist and a number of other choice words as a kind of game of political hardball. And in turn, Jefferson accuses Adams of being a Protestant pope and insisting on his black-cloaked Puritan clergyman to be running the office. I mean, there's an awful lot of political invective going in there. Interestingly, in the 1787 Constitutional Convention and in the discussions around the First Amendment's formulation, all the concern is about making sure that this legislative branch is very, very clearly circumscribed in the enumeration of its powers, in the methods by which people are selected, and being very, very careful in calibrating it. The legislature gets a lot of the work in the Constitutional Convention. The executive branch, less so. The real concern is making sure that the executive does not become another king, making sure that we put constraints upon how the executive can operate, putting various kinds of checks and balances in place, advice and consent being put in place, and circumscribing the executive power, but not spending a great deal of time in Article 2 laying out the details of that. And the judicial branch is the least defined. Article 3 is a rather primitive, as you know, and the thought is that we'll have a Supreme Court, but much of the judicial power is kicked back to the legislature in Article 1, and you guys have the power to create inferior judicial tribunals, and we'll work it out. Pretty quickly, we get the Judiciary Act of 1789, the same year, which gets amended several times. So they had ideas about this, but they don't spend time in the Constitution kind of laying it out. The real worry that every draft except the first one makes clear is that we don't want this powerful new branch that we've created with necessary and proper power and with taxing and spending power to be in the business of controlling religion in any particular way, or controlling especially state religions. They didn't imagine the executive having much power beyond that which was delegated to it and circumscribed by the Constitution text itself, and they certainly didn't imagine the judiciary having kind of untoward power. That changes, and there's a lot of movement in the 19th century. All these Blaine amendments in particular that emerge, 13 attempts to try to amend the Constitution, and many of those amendments that we get, all of which fail, that are trying to amend the First Amendment, change it, refine it, revoke it, are in part directed at trying to curb the power of the federal courts and curb the power of the executive. None of them passes muster. So we get I think there was at least tacit understanding that the electoral process for the executive would do some of the work. And I think there was an explicit thought that the legislature, in its power over the inferior tribunals, would provide a pretty substantial check on what the judiciary could do. They still didn't imagine a lifetime appointment to the federal bench. R.B. Madison is a few years down the road, and they didn't have an idea of judge-made law that was particularly well developed. You did hear, though, in the discussions in the House, the worry about generic provisions on religious freedom putting questions before the federal courts. And several times that's mentioned by some of the representatives in the House. And there is a recognition that when you put this Bill of Rights in place and operationalize it, it has to be operationalized in part by the federal courts. And certain kind of things we don't want to put before the federal courts, especially when they come out of the states, is one of the importance of that. But there's a recognition that the judiciary is going to be active. But exactly how is not really spent. They don't spend a great deal of time trying to lay it out. and as a consequence, don't put a lot of constraints upon what the executive and judicial branches can do. Better to give them no jurisdiction than to decide how the jurisdiction should be exercised, I think is the point.
Sure. Similar to the Bill of Rights argument.
Yeah.
Yeah, that makes sense. Certainly. Well, thank you so much. Do we have any additional questions or comments from the audience before we wrap up? I never know how long to wait before closing it, but if we don't, I will go ahead and say thank you so very much, John. That was absolutely fantastic. Really enjoyed that. And if we could give you a little online round of applause, take me 1 second. There we go. Or no, wait, that's the wrong one. Applause. There we go.
I'll take the applause in whatever form it is. I appreciate the opportunity to talk with you a bit about these arcane matters. It's a vexed area of constitutional discussion these days. Legal historians don't weigh in as much in this area as perhaps they should. Carefully parsing text rather than simply, doing potted history is a less glamorous form of the work that goes into the originalist project. But in my view, not being necessarily an originalist, but interested in what the original understanding is, I think we get pretty far along by taking these early texts seriously. I'll just end with a little anecdote, which is the argument that I laid out for you in the piece and summarized in our discussion today. I had the opportunity to present a version of this to the greatest of originalists, Justice Scalia. It was a Fifth Circuit Court of Appeals conference, and he was there, and I happened to be their keynote. And I laid out this argument. And my chief interrogator in front of the 400 members in the audience was Justice Scalia. And he pushed and pushed and pushed and hummed and hawed. And it was, what was interesting to him is that for him, the greatest of originalists on the bench at least, a lot of this stuff was new. And I found that amazing. For a brilliant guy as he is, deeply trained as he is, interested in history as he was as a Chicago law professor and then early member of the bench. So we come to the story of these Bill of Rights provisions with an awful lot of baggage and an awful lot of set of assumptions. And what historians, I think, could do, what we legal historians could do, is to let the sources speak and speak unabridged. And then on the strength of that, start making the judgments that we have to make about the ongoing salience of this stuff. So if Scalia thought there was something in this, I thought it may be useful to put it on paper, which is what I've done, and bored you with it as well. So I'm grateful for the opportunity to see you. If I can be of any help to any of you, drop me an email at Emory. It's jwitte@law.emory.edu. It should be on my Emory Law School profile, and just drop a line if I can be of any help to any of you.
Wonderful. Thanks so much. We look forward to welcoming you to Cambridge in person one of these days, and we will be back 2 weeks from today with our next seminar. So we look forward to seeing all of you then. Thanks so much.
Thanks. Be well. Bye-bye.
Well.